from
This conference will now be recorded.
Oh, I see Harold's on. Yeah. Okay, good.
Good morning, everyone.
Good morning, Director Williams. We've got 2 minutes. Should we wait 2 minutes to start?
Yeah, we can't start before 11:30.
Okay.
You want to
This
start?
conference will now be recorded.
All right. It is now 11:30, and I'll call the Finance and Administration Committee and special meeting of the board to order. And we know there's a quorum of Director Williams and myself, committee members. Is there any public comment?
I have no request for public comment.
Okay. Presentations?
Yes, we have a presentation. We have a presentation from our bond counsel, Doug Brown, our longtime bond counsel, and sometimes I think the only bond counsel in all of California. Doug is everywhere. That's how good he is. But anyway, he is with Stradling, and the reason we're doing this disclosure responsibility training, we're going out to the market here shortly in May to refinance the 2011 series of bonds and also some commercial paper, close to $80 million. So Doug wants to give us a refresher on the disclosure responsibilities under the federal securities law. So I'll hand it over to you, Doug, to do the presentation. Thank you.
Great, thank you, and good morning, Director Williams and Director Deere.
Morning.
The Securities and Exchange Commission, which is the federal regulatory agency that governs the municipal market, has recommended that public agencies have periodic disclosure training. West Basin adopted a disclosure policy many years ago, and that disclosure policy also says that both staff and the board of directors will receive disclosure training periodically. If you are a frequent issuer, we would recommend that you do it every 2 years. You're a relatively infrequent issuer, and so typically issuers like yourselves do this sort of refresher training prior to doing a new bond deal. So that's why we're here today. So if you would flip to the next screen. As a reminder, the reason disclosure is necessary is because you do issue securities in the public credit markets. And under federal securities laws, investors have rights, and that the primary right is that they're entitled to all material information being disclosed to them. And we're going to talk a little bit about the various ways that information gets disclosed to investors. So if you go on to the next slide, there's really two federal securities laws that are relevant, the 33 Act and the 34 Act. Now, your staff has had much more detailed training, and I've gone into the subtleties of the 33 Act and the 34 Act. I really won't do that with you, but if you are interested in that, you can get a copy of the more detailed training from Margaret. But each of those acts does require the district to not make an untrue statement, and also not to omit material information. So two responsibilities: accurate when you speak, and when you speak, you cannot omit material information. If we go on to the next page, Rule 10b-5, which is the rule most frequently cited in this area, says it's unlawful for any person, and person includes public agencies. So read that as it's unlawful for West Basin, B, to make an untrue statement of a material fact or omit to state a material fact necessary in order to make the statements in the light of the circumstances under which they were made not misleading. So again, statements have to be accurate, and you can't omit information. Now, as the rules indicates, if there's a misstatement or an omission of an immaterial fact, that's not actionable. It's only material facts that are of concern. So if you go on to the next page, one of the reasons why the disclosure compliance is important is about 8 or 9 years ago, the Securities and Exchange Commission, who was not very interested in the municipal bond market, became more interested in the municipal bond market. And that's a result of a couple of reasons, but one, just people who were appointed to the Securities and Exchange Commission were more interested in that topic. As a result, the Securities and Exchange Commission has hired more enforcement staff, including enforcement staff in San Francisco. So over the years, there have been enforcement actions against public agencies in California. That goes all the way back to the early 1990s. And if you remember, the Orange County, just to the south of you, filed bankruptcy as a result of some imprudent investments in their investment pool. And part of all of that was an SEC investigation. The city of San Diego has also had enforcement action brought against it. Westland's Water District more recently, about 5 or 6 years ago, had one brought against it. Montebello Unified School District just recently entered into a settlement. So it's not like there's an enforcement action every week, but it is also the case that there are periodic enforcement actions here in California by the Securities and Exchange Commission. So if you go on to the next slide, neither the 1933 Act or the 1934 Act tells you a definition of materiality, unfortunately. So how we determine whether things are material or not is a function of both lawsuits that have occurred that the SEC has been involved in, or these enforcement actions, which we just talked about. So the best that we, as your attorney, can tell you, something is material if there's a substantial likelihood that a reasonable investor or a prospective investor would consider the information important in deciding whether or not to invest. Key there is this is a relatively low bar for the Securities and Exchange Commission because they don't need to prove that there's actually an investor that believes they were misled. The SEC can take the position that a reasonable investor, quote unquote, would have thought something was important. A second thing I'd say here is, remember, when people are looking at whether something is material is when probably there's already a problem, right? And so as we talk to your staff about what is or is not material, one of the things we often say is, you know, if you would feel more comfortable telling people about it now in your official statement than you would in a deposition trying to explain why it was omitted, you know, we would advise you to disclose because, you know, it's never a fun situation to find yourself in a deposition trying to justify what you're thinking or what the district's thinking was 5 or 6 or 10 years earlier. As I said, the guidance in this area has come mostly from court cases or enforcement actions. Private companies often litigate the SEC to the bitter end. Public agencies have a tendency to settle relatively early. And so most of the guidance in our area is through these settlements that public agencies have entered into. So if you go on to the next slide, there's really 3 instances in which you need to be thoughtful about whether what you're saying is accurate and not misleading. First of them is a new offering. And as your general manager said, we're anticipating a new offering later this year when you go to refinance some of your debt. And in connection with that offering, you will put out an offering statement, and that offering statement has to be accurate and complete. Secondly, each year your staff files what we call the annual report under Rule 15C212. It includes your CAFR and your comprehensive audited financial statements, and it also includes updates on certain operating information, water sales, water revenues, and the like. That annual report is subject to the securities laws. And then a third area, and we used to believe this was not a significant concern, but we're going to talk in a minute about why it's more concerning now than it was in the past. The third circumstances is where an issuer is speaking to the market, quote unquote. And we used to think that meant a very senior staff person, maybe your general manager, maybe your CFO, is giving a speech in a context where they know the rating agencies or big bond investors or bond underwriters are in the audience. And we used to say, hey, if you're giving that speech, if you're giving a speech at Aqua, for example, and the topic is the financial effects of COVID on water agencies, and if Margaret were giving that speech and she walks in the room And she sees people like myself, and she sees financial advisors, and she sees Goldman Sachs and Citigroup and people like that represented there. She's on notice that she's speaking to the market. And under those circumstances, we would say she has to be accurate and complete. So if you go on to the next slide, we'll first talk about this official statement that we'll be preparing in connection with your new offering. That official statement is an offering document to investors. It has to contain all material information. It is West Basin's document as a legal matter. It may reside on our word processing system, but legally, the district is responsible for the information that's in there. And one of the things the SEC made clear in the Orange County settlement back in the 1990s is that while you have the ability to rely upon your underwriters, your financial advisor, your lawyers, at the end of the day, the district is ultimately responsible for the content of that official statement as a legal matter. So go on to the next slide. This official statement is going to be developed in a 3-step process. Your executive manager of finance is going to work with relevant staff to prepare a draft of this official statement. When it's substantially final, it's going to go to your general manager for his review and input. And that's because the securities law require your manager to certify before it's sent to investors that it's deemed final is the term of art. But basically, your general manager has to certify that the process is complete. And then that official statement or preliminary official statement is going to go to you, the board, for approval as part of the approval of the transaction. And when it goes to the board is, again, as the SEC made clear in the Orange County case, the board is obligated to have reviewed it. Now, the board's not responsible for every single fact in there. I think the SEC would say you're responsible at a relatively high level of making sure that the appropriate issues are included in the official statement. So that's why that document is provided to you as part of the process. And if you do have questions, comments, concerns, we'd encourage you to reach out to Margaret and raise those so that we can address those. The whole process of developing this document, it's important to maintain the attorney-client privilege, meaning if you do have communication or any of the staff has communication with respect to things in the official statement, it's important just to communicate them to staff or to your lawyers and not raise them more broadly. Once they're raised more broadly, then that document is in effect in the public, and we don't want it getting out to the public until later in the process, once everybody's confident it's complete and accurate. Just a reminder, political sensitivity or confidentiality is not an exception to disclosure. So for example, if there were something going on at the district that the district had agreed to keep confidential, let's say it's an investigation, or let's say it's a negotiation on something very material. If you've signed a confidentiality agreement, you either have to get an exception to that confidentiality agreement, or you cannot issue debt. Because if that confidential item is material, you're obligated to disclose it. If you can't disclose it, then you can't finance. And we've had a couple instances in the last 10 years where we've had to advise districts that they can't go to the market because there's something going on at the district that is subject to a confidentiality agreement and therefore can't be disclosed. So if you go on to the next slide. So timing considerations for a bond sale. Your staff is working on a preliminary official statement. It's going to come to you ultimately for your review. It's called preliminary, but that's really a misnomer. The securities laws require to be complete. The only things that can be blank at that point are the actual amount of bonds and the actual interest rates, because you won't have sold the bonds yet, so you don't know for sure what those are. But other than those, what we call pricing terms, that POS has to be final, and your GM is going to certify that it's final. That POS, after you approve it, will go out to investors. Usually about 7 or 10 days later, there's a bond sale. Now, typically, West Basin has delegated to its general manager the authority to actually sign the purchase contract. And then after the sale, we produce what's called the final official statement. But that document should be identical to the preliminary, other than we will fill in the amounts and the interest rates. And then like buying a house, about 7 or 10 days later, the transaction will actually close. If anything changes after the POS has been approved and it's material, you're obligated to file what's called a supplement, basically to update the disclosure. So if a significant lawsuit is filed, or God bless, if there's an earthquake and there's damage to your facilities or something like that, after the POS is published, we might have to go back and publish a supplement. And then even after closing, the district has an obligation to update the disclosure for 25 days. So actually, we will close at some point during the summer. You'll have the money, you'll get the benefit of the refinancing, but we will still be working with your staff up to 25 days after closing if something material has occurred to file these supplements. So on to the next slide. Then we talked about the annual report that's filed each year. I won't spend much time here. As I said, you have to file your audited financial statements, and you have to update certain operating information. You have to do that within 270 days of the end of your fiscal year. And the SEC takes this very seriously. About 5 or 6 years ago, they did a big enforcement action, and hundreds of public agencies were sanctioned for either late filings or incomplete filings. So this is something your staff has always taken it very seriously, but it's something which on a go-forward basis also has to be taken very seriously. So if you go on to the next slide, I know this is sometimes counterintuitive to you all because you're a public agency, but the securities laws don't require you to communicate with investors, individual investors who might call you, might call your staff. And I know there's some tension between the market who wants more and more information and the fact that if you give out information, you may be taking on some liability. So we encourage agencies, and West Basin has appointed a single point of contact, which is Margaret. So if any staff or any board members for that matter get calls from people who say, hi, we own some of your bonds and we'd like to talk to you about X or Y or Z, our advice as your lawyers is refer those people to Margaret. And you're doing that for 2 reasons. One, you want West Basin speaking with a single voice. You don't want different people saying the same thing, but with slightly different language. But the second thing is it behooves everybody at the district to make sure that only publicly available information is being given to investors. I'm sure you've all heard of insider trading, and you think of that mostly in corporate finance, but it's also a concept here. If somebody at the district were to give one investor information that's not public, that investor could go out and either buy your bonds or sell your bonds, and that would be insider trading. So again, your staff has been trained that if somebody calls them and asks for information, they only provide information which is already publicly available. So if we go on to the next slide, I mentioned earlier that the speaking to the market concept has changed, and that's as a result of a SEC staff legal bulletin issued about a year ago. And now a staff legal bulletin is not the law. It's not even been approved by the SEC board of directors, but it's an expression of what staff believes to be true. And the SEC staff believes to be true something very different than I think professionals like myself thought was true up until a year ago. They believe that all statements by the district reasonably expected to reach investors are subject to the anti-fraud provisions. And so as we all try to figure out what the SEC means, a couple things have been clear. The fact that the information wasn't published for the purpose of informing the market is not relevant. So we used to believe that only information made available to investors was covered by securities laws. Now they're saying, no, that's not true. So we will see over time what that means. But for instance, it might be the case that when your staff presents quarterly financial results to you at your board meeting, and because those quarterly financial results are available, to anybody who, gets your agendas, it may be the case now that those quarterly financial results are subject to the securities laws. If you go on to the next slide, though, specifically, I'd advise the board members. The SEC does not seem to be making a distinction between statements by the district staff and statements by district board members. So I think as you give speeches or presentations, if those speeches and presentations are to the general public, you might someday be told, well, those speeches are subject to the securities law rules, meaning you have to be accurate, which I'm sure you always are, but also have to be complete, meaning if there's some unhelpful information on the general topic, the SEC might say you were obligated to give that less helpful information to the public. So I would just remind you that potentially when you make verbal or written statements, to the general public, you might be subject to the federal securities laws. If you go on to the next slide, your staff has gone through sort of the types of enforcement actions the SEC has brought in detail. With you, I would just say, there have been a lot of SEC settlements, including against the state of New Jersey, the state of Illinois, the state of Kansas. Originally, meaning 10 years ago when this new wave of enforcement started, typically they ended with fines against the public agency. More recently, there have been fines against staff people at public agencies if it's determined that the staff people, did something egregious. And there have even been, in very serious cases, and for example, the city of Ramapo in New Jersey, they literally kept two sets of books, the real set of books and a set of books that they used to show investors when they financed a minor league ballpark. Obviously, that's very egregious. Those staff people who worked on the financing were barred from involvement in the municipal finance market in the future. And if you think about it, what that means is they could not really ever get a job at another public agency, right? Because they wouldn't be able to work on that public agency's financings. But again, that's in an extreme situation. So if you go on to the next page, there have been situations where officials who didn't participate in a bond deal were charged, and that's because they overstepped their role, and got themselves, while they weren't formally in charge of the bond deal, they got themselves overly involved with staff and were advocating things. So that's always a concern. Occasionally, there have been criminal charges. Again, that's the city of Ramapo, where people literally kept two sets of books. So that's very, very rare. So if you go on to the next slide, SEC investigations generally end in a settlement, and typically the public agency doesn't admit or deny that they violated the securities laws, but they agree that they won't violate them in the future. Sometimes you have to hire outside monitors to monitor your behavior for a period of time. The city of San Diego, for instance, it went on for years and years and years. They had to pay consultants to monitor their debt program, and it became very expensive. A reminder that the SEC can bring an action even if you don't default on your bonds. In fact, most of the enforcement actions in California have been situations where there was no default in the bonds. And the SEC doesn't have to prove that anybody actually lost any money. So on to the next slide, which is just, I think, the last slide. So the consequences of bad disclosure is an SEC investigation is expensive. You're going to pay lawyers and consultants like myself a significant amount of money. While SEC investigations are confidential, they eventually end in a settlement, and that becomes public. And so everyone will be aware of what the alleged behavior was. There may be fines. You may be out of the market, meaning if there's an SEC investigation going on, you may not be able to access the credit markets. That's an instance of where there's a confidential investigation going on that you can't disclose. You may have to impose new procedures. Now, that's probably not the case here. You already have adopted disclosure policies and you do this disclosure training. Those are the procedures which normally the SEC would require. And you may have a ratings downgrade. So then just in summary, I think there may be one more slide. But in summary, the key terms is all material information has to be disclosed. When in doubt, we advise disclosure. The district has and should continue to support and encourage vigorous disclosure. They should continue to do the training, which is what we're here doing today. It's important to protect the attorney-client privilege, as I mentioned before. So if you do have questions or concerns, make sure they're funneled through the district staff and the district council. We advise adopting disclosure policies, which you've done, and having training. And as I said, the new issue right now over the last year has been this new SEC legal bulletin, which seems to pretty dramatically expand who is covered and the type of statements which are subject to the federal securities laws. And in the coming years, I guess we'll find out exactly what the SEC means by all this. So with that, happy to answer any questions, or you can provide questions to Margaret. And as I said, the more detailed training is available. PowerPoint is available to you if you'd like to see it.
Well, I think it was an excellent presentation. I would like to see my colleagues on the board that aren't present today get this presentation somehow too. I think it's very important they do, particularly since we have two fairly new board members who are more likely to stumble, I think, than the old timers, my opinion. Pat, I don't know how we can work that out where they can.
Yeah, we have on the call, we have Director Williams, we've got Director Houston, and Director Alvarez joined at 1:47. And the presentation is in the packet. Director Gray has not joined the presentation, so we'll make a point to make sure that she receives it. And if she has any questions, we can bring it back to bond counsel.
Thank you.
Dr. Deere, if I can add just a few comments. So just to Doug's point, staff did have training on February 4th. I did invite all managers as well as the finance team and any others that were interested in to participate. And as far as it relates to the bond document, we have put together some preliminary numbers. Our intent is to bring the document to the board in April, if we can keep that schedule, and so that we can get into the market in May. If not, everything will just slip a month, but that is the intent. So you'll be looking forward to seeing not only the preliminary official statements, but all the related bond documents associated with it. So I just wanted to share a bit of the timing associated with you. So, and I appreciate your time on this. As you can tell, it's a very important topic, and rest assured it's very important to me that we make sure we have full and a complete disclosure.
And if I may add to that, Chairman Deere, I did say there that Director Alvarez joined us at 1:47. That's at some point in the future. It's actually 11:47 today. The meeting started at 11:30. Sorry about that, Director Alvarez. Thank you, Director Deere.
Thank you. All right, we'll go on the agenda then. That was a very good presentation.
Okay, so that brings us to the action calendar, where we have 3 items. The first item on the action calendar is the approval of the board minutes. And the particular recommendation here is that the board approves the February 22nd, 2021 regular board meeting minutes.
Director Williams?
I so move that this goes on to the board for final approval.
I agree. Any other comments from my colleagues? All right, well, those are approved to go onto the board.
Okay, thank you. Our next item is the first in a series of 2 resolutions we have before the board for approval to have the board president sign them. This one pertains to our capitalization policy, which We review periodically to see that we're in compliance with GASB rules and other rules, and that it's fully up to date. And we have, we have Wendy Nakamura from our finance department who's going to present this item and read the recommendation when she's complete. Wendy, please.
Thank you, Patrick. Good afternoon, directors, member of the committee. I will cover agenda number 5B in your package from page 33 to page 49. On page 33, I just want to give you a little bit of background about this agenda. West Basin has developed capitalization policy to provide guidance on what expenses should be capitalized either at the time of the purchase or at the time of the completion of the construction project. Capitalization policy allows West Basin to depreciate the cost over the estimated useful life instead of expensing the cost in one single fiscal year. A simple example would be we bought $20,000 furniture, and if this furniture lasts for 5 years, we would capitalize the $20,000 and depreciate over 5 years. So each year, our expenses only going to be $4,000 instead of $20,000. Another example would be if we complete a $10 million construction project, we will first define the major component in this project, and then we'll depreciate each component based on estimated useful life. To ensure the capitalization policy reflects the most recent accounting guidance, we reviewed Government Accounting Standard Board Statement number 34, number 42, number 51, and number 87, which address the capital asset related to the state and local government, asset impairment, intangible asset, the lease asset, and financial reporting of the capital asset. Because the current policy in Admin Code Part 4, Chapter 1 has not been revised in several years, therefore we recommend a new policy to replace the current policy. A summary of the changes are listed on the bottom of page 33 and the beginning of page 34. West Basin's auditor and the district council has already reviewed the policy, and the district council prepared a resolution to incorporate in the change into the admin code. We would also like to bring to your attention that there's no change on minimum capitalizable value of $10,000 and the minimum 3 years from the current policy to the new policy. Therefore, there is no financial impact to West Basin. The updated policy is included in your package from page 33 to page 43. The current policy is included in the package from page 44 to page 49. With that, please let me know if you have any questions I can answer.
Board members, any questions?
None for me. I see that this has been reviewed, the report or agenda item has been reviewed by our finance executive manager and also by the general manager. So I'm satisfied with this.
Fine, we'll send this on to the full board then for approval.
Thank you.
So now I will read a recommendation on page 34. We recommend the board approve, adopt, and authorize the president to sign resolution number 03-21-1122, which is on page 35.
All right, that's the recommendation. Again, Any of my colleagues have comments? If not, it's been approved by this committee. We'll go to the board with it. Thank you.
Thank you.
Okay, our next item is the item 5C, which if you go to your board packet, page 50, it starts there. And this pertains to our tuition reimbursement and professional reimbursements policy. You may recall we brought this to the F&A, this committee, back in December, and we presented an update on the reimbursement process. We also, Michelle Green, our HR manager, presented subsequent, maybe at that meeting, some comparisons to what other agencies are doing and some possibilities for us to move forward. We were asked to bring back to this board, once we reviewed it further, some suggestions for the policy to bring it more in line with the industry. And this is for at the board's discretion. Michelle Green, our HR manager, is here to present on this item. Michelle.
Thank you, Patrick, and good afternoon, Chairman Deere and members of the board. Today I'm presenting this item, as Patrick mentioned, on the tuition reimbursement policy. West Basin has an established tuition and professional reimbursement policy to encourage employees to pursue pre-approved educational and licensing certification opportunities. So this policy is reflected in the administrative code in section 3-4.216. And the current policy establishes procedures where an employee must follow in order to request a reimbursement. So at the December 11th, 2020 Finance and Administration Committee meeting, staff presented an update to the board regarding the tuition reimbursement process, including the history of tuition reimbursement expenses over the past 5 years and a summary of what other agencies offer employees under this benefit. And it was also indicated at that meeting that a revised policy would be brought back to the committee at a later date, which I'm doing today. So as a reminder, to give further background into this item, at the October 16th, 2020 committee, the board inquired, as I stated earlier, into the district's current tuition reimbursement program, and specifically asked for or requested an update on several items, one of which was a summary of what other agencies offer its employees under this benefit. So as I stated earlier, staff presented that information at the December 11th, 2020 committee, which is reflected here on page 51 of the packet. There is a chart, as you will see, which gives detailed information on what other agencies similar to ours offer in terms of tuition reimbursement. As you can see under the reimbursement limit, currently West Basin's limit is 90%. So our current policy indicates that for tuition reimbursement and for certain licensings and certification, that the district would reimburse up to 90% of that tuition. However, if you look at this chart here, you can see that a number of our like agencies have a reimbursement limit. Specifically, if you look at Metropolitan Water District, they have a $9,000 limit per fiscal year. The other agencies have limits based on each course. For example, Las Virgenes has a $685 limit per course, and so on and so forth. There are only a few agencies that may offer up to 100% of reimbursement. Water Replenishment District is one of those. Now, staff has prepared a revised tuition and professional reimbursements policy, which is included as attachment A, and that is referenced on page 53 of your packet. Essentially, some of the more substantive changes that have been made from the old policy is that we did implement a reimbursement limit. There is further clarification of the Internal Revenue Code, section 132J8, There's some clarification on the fact that license and certification renewals would be fully reimbursable by the district and not subject to a reimbursement limit. There was further clarification in the new policy that certain fees are excluded from reimbursement. And this new policy also offers further clarification on repayment if an employment leaves district service. So if you reference, as I indicated earlier, page 53 of the packet, which is the new policy, and what we're suggesting as well or recommending is that the old policy be completely replaced with the new policy, which would be titled Employee Development Program. And on page 53, I'll again just highlight those sections that are where the more substantive changes have been made. So we've made reference in the new policy that under Internal Revenue Code section 132J8, amounts that are paid or expenses incurred by the district for the education and training of employees are excludable from gross income only if such amounts or expenses are considered a working condition fringe benefit. So job-related education is not taxable to the employee if the educational expenses qualify as a working condition fringe benefit and meet the definition of job-related training under the Treasury Regulation 1.162-5 and are made to meet any of these three requirements that are noted here. One, to maintain or improve the employee's skills for the employee's current position with the district, meet any specified educational requirements of the district, or meet any requirements necessary for the employee to retain their salaries or their status of employment. This new policy further goes on to state if educational courses are taken for general education purposes or are needed to meet the minimum requirements of the job or are part of a program of study that qualifies the employee for a new trade or business, then such courses do not qualify as a working condition fringe benefit. Another item that I want to note, a substantive change in the policy is on page 54 of your packet under eligibility, where we indicate that only active full-time employees who have completed the initial probationary period, as referenced in section 3-4.101B of the admin code, with the exception of those employees serving a promotional probation period and achieve regular status with the district, may be reimbursed for reasonable costs for tuition, registration fees, books, and lab fees for educational courses related to district employment. That language is actually in our current policy, but we've implemented new language in this new policy that indicates student association costs, health fees, and other additional non-educational fees are excluded from reimbursement. That information was not in our current policy, so we have added that as a substantive change as well. Another substantive change you will see on page 55 of the packet, where we make reference to the fact that funds that are received from outside sources, such as scholarships, grants, veterans, or other educational benefits, must be applied towards the cost of the course before the district's reimbursement is applied. That's one substantive change. And one of the major changes, as I indicated earlier, under number 2, reimbursement requirements, is that the maximum amount eligible for reimbursement is $9,000 per fiscal year. And under this same requirement, it states that license and certification renewals, contact hours, or recertification units will be fully reimbursed by the district and are not subject to the $9,000 eligibility amount. That's another substantive change. And lastly, we make reference at the bottom of page 55, where we advise staff that reimbursed expenses may be considered taxable income and may be subject to tax withholding. So the employee shall seek independent tax advice as a district is not liable for that determination. So we thought it prudent to put that information as well into the new policy. And lastly, in the event that an employee leaves district service within a 2-year period, we have specified at the bottom of page 55 of the packet and the top of page 56 of the packet that if the employee separates from the district within 1 year, they must reimburse the district 100% of the tuition reimbursement that was paid to them. Or if they separate within 2 years, they would have to reimburse the district up to 50% of that reimbursement. So those are the substantive changes that were made to this new policy. The code further comprises, our admin code, I'm sorry, further comprises a tuition reimbursement benefit for the board under Part 2, Administration, Article 5, Director Benefits. So please note that if Section 3-4.216, which I'm presenting today, if those amendments are approved, staff will be required to amend Section 2-1.509 under the director's benefits article as well. The benefits to West Basin of reviewing our admin code on a periodic basis is that the district must remain in compliance with changes in federal and/or California labor laws, to remain in compliance with Internal Revenue Service codes and regulations, and to maintain effective policies that govern employment. Further revisions to the code are required to ensure that employees are fully aware of the provisions that govern their employment with West Basin and to ensure best management employment practices. So if there are any questions, I'd be happy to answer those.
I have a question. Have there been abuses of this policy in the past? Is that why we've added all these stipulations?
That's a very good question, Director Deere. No, there has not been abuse of the policy. However, as you can see in terms of what the district offers, it's very generous in comparison to what other agencies have offered. And in order to be, I think, a more fiscally prudent and fiscally not to say that we were irresponsible before, but the limit that we had, which is 90%, if the individual went to, say, for example, a private school setting versus, say, a private university setting or versus a public university setting, that tuition could be very, very high. And so, and we're just looking at other agencies and what their practices are and coming more in line with what those practices are as of today. And so this policy is still generous in terms of what the district would offer, because there are not many agencies that offer up to a $9,000 a year limit or fiscal year limit. And so we are looking at the highest that we can possibly pay in comparison to other agencies. But it's just a matter of reviewing what other agencies are doing and to be more in line with what is happening in the general water agency industry.
A question for Patrick, if I might. Patrick, does this particular perk that we're discussing affect our recruiting?
Well, first of all, I'm very much in favor of the tuition reimbursement. I think it's a great tool, yeah, both for recruitment and retention of employees. Like Michelle just said, though, I think it remains, as laid out here for the board, for the committee, it remains a very fair and is in line with the water industry. So we're not, I would say, to answer your question directly, it's always a good recruitment tool, but balancing that with, making sure we don't have an unlimited or potentially hundreds of thousands of dollars in tuition reimbursement at the taxpayer's expense. So there has to be some kind of balance there. So good recruitment tool, good retention tool, and I think what's before the committee is fair changes and updates.
Thank you. Other questions from board members?
Yeah.
Harold?
Jared, thank you. Yeah, I was going to ask follow-up question on retention, and you covered that. But I don't know if I remember hearing if that whether or not our reimbursement for classes or courses or degrees are based on what one would pay at a state university, or the sky is the limit. You could.
I'm sorry, Director Williams, if I understand your question correctly, you're asking if we currently have a limit in our current policy?
Yes, and going forward, when I was in the workforce working for cities, our reimbursement amount was based on what you would pay at a state university. So if you went to Cal State, Long Beach, or whatever, that was a whole bunch cheaper than going to USC or some other place. So for this, for the benefit of the ratepayers or our taxpayers, we went to what if we would only reimburse at the state school level rather than private school levels.
Understanding your point exactly. So our current policy simply indicates that we will reimburse up to 90% of the tuition. So it does not specify whether that tuition must be from a state university or from a private university. And so as you can imagine, the amount, 90% of what a state university would charge versus what a private university would charge can be significantly different. So there's no specifications in our current policy as to whether or not we would pay 90% of a private university or a public university. It's just 90%. The new policy would specify that we'll only pay $9,000 per fiscal year. And again, we're not specifying whether that's public or private. If it's a public university, that $9,000 could inherently pay for their tuition for that year. If it's a private university, likely not, but we are setting a limit, whether it's private or public, or recommending that we set a limit for that tuition reimbursement for which is $9,000 per fiscal year.
Okay, so our policy then is a good recruiting tool.
I believe so, yes, because there are a lot of agencies that their caps are much lower, or they will offer a cap per course. And so I do believe that it's still a very good recruitment tool, because you will find that, a lot of agencies don't offer tuition reimbursement at all, or if they do, their limits are much lower.
That could be why we have this high level staff that we have, highly educated.
Well, I will, excellent point. I will say that a large majority of our staff already had degrees, undergraduate and graduate degrees when they came into the district. So, but we do have, some new employees who are seeking now more professional or graduate degrees. So we do have a very highly skilled group of staff here at West Basin. I can definitely attest to that.
Oh, very good, thank you. So that's also is a good retention tool as well.
Yes, I think so.
Yeah, all right, thank you.
You're welcome.
Well,
Go ahead.
I was going to say, if there are no other directors wishing to speak, I think there's Director Alvarez.
Yes, I have a couple of questions. Part of the policy says that funds received from outside sources, such as scholarships, grants, etc., will be applied first. How is that going to be verified?
That's a very good question. What we would have to do in terms of that is ask the employee to submit any information that they have, in terms of scholarships or any other benefits that they would have received. A lot of students who are applying may go through through their schools, their universities' financial aid program. And so oftentimes they may submit information, pursuant to what they received or the application that they received through financial aid. So hopefully, someone will be, of course, as honest as possible in providing whatever information that they have to prove that they have received additional resources elsewhere before we apply the tuition reimbursement policy that would be implemented here at the district.
Would it be possible to then ask, normally you apply for some kind of aid and you get a notice, either you've been awarded the aid or not, that they provide a copy of that?
Exactly. That's the type of verification that we would require for staff to provide. And in fact, you brought up a very good point, Director Alvarez, in that the form in which we would ask employees to submit their request for reimbursement, we would also likely implement a tool on that form itself that indicates if they have received any scholarship or outsourced funding, that they must provide proof of that and check a box that indicates that they have received such benefit and thereby provide that proof. And their signature on that would be, their verification that they did or did not receive any outside funds. So that's a very good point, and that's likely something we would add to the form where they request reimbursement in the first place.
Okay. I have another question, and that is the policy right now will reimburse them up to $9,000 per fiscal year. And so what happens if an employee undertakes a program of study to get a degree and incurs, let's say, $27,000 worth of expenses, and then drops out of the program and never finishes it? I understand that if an employee leaves, he is to reimburse the district either 100% or 50%, but an employee stays and just decides after a while that, he or she wanted a degree, and after pursuing that degree for a matter of time and incurring expenses for which the district has reimbursed and absorbed that expense, then decides to discontinue it for whatever reason. Maybe it's not something of interest anymore. Other responsibilities have taken a higher priority and don't have the time to continue the course of study, etc. What would happen in that situation?
Well, as it states right now, I believe the policy indicates that we would pay for completion of that course. And so we don't pay the full, say, for example, someone submits an application that says that their 3 or 2 year course program would cost in the amount of, let's say, $25,000. Again, the individual has to be advised that we're only going to pay up to $9,000 per fiscal year, so they would not be getting paid that full amount. But in essence, we're paying for the completion of each course. And so if the individual decides, so we're not paying them that amount. Say, for example, again, the form indicates that the 2 year program is going to cost $27,000, $30,000, something like that. We're not giving them that money up front. We're giving them simply the money that they paid for their course once they show us documentation that they have passed that course with a grade C or higher, and or a pass-fail if it's a pass-fail situation. So if they don't complete the entire program, then in essence, they're not going to get paid that full amount that they asked for in reimbursement when they first applied for the program. What we would hope is that the district and the employee would have benefit from whatever courses that they did complete, and thereby whatever educational experience and information that they gained from taking that course would be a benefit to them in their employee development, and for the district as a whole. But we don't pay that full amount up front. We simply pay once the individual shows proof that they have completed the course with a grade C or higher. I hope that answers your question. I'm not
sure.
That
answers the question. They don't have to complete a degree if that was the intent. They'll just, whatever they complete, they just get reimbursed for. And if they don't finish, they don't finish.
That is correct.
But
I will say in most cases, though, Director Alvarez, most of our employees who have requested tuition reimbursement have completed their course program. That's been our history so far.
I'm glad to hear that.
Mr. Chair,
Go ahead, Director Williams.
thank you. Since we require a C or better grade in order to receive the reimbursement, now this is at the undergraduate level. At the graduate level, you have to receive a B or better to indicate that you have completed the coursework. Have we looked at having a B or better at the graduate level rather than just a C? Because a C is kind of frowned on in graduate school.
We have not looked at that. As long as it's a passing grade, Director Williams, and historically in looking at other agencies' policies as well, you will see across the board that whether it's undergraduate or graduate program, that a C or higher would be acceptable for a passing grade. So while it might be frowned upon at some universities in a graduate program, we have not specified that in our policy. We simply ask for a C or higher because that's been the standard across the board at within other agencies' policies.
Okay, thank you.
You're welcome.
Other questions?
Yes, Mr. Chair.
Go
Really,
ahead.
no questions. Thank you, Michelle. I think it's very thorough. I think it's very generous. I think that it still puts us in the top of the agencies, around our area. So I fully support it as written. So thank you, Michelle.
Thank you, Director Houston. Appreciate that.
Director Williams, do you agree we should send this to the board for approval?
Yes, I do. Thank you very much.
All right, we'll do so then. The recommendation, which we can all read. You want to read it aloud for the record because it's being recorded?
Yeah.
Go ahead.
Yes, I was just going to say, Director Deere, that if there aren't any more questions, I will go ahead and read the recommendation, which is that the board approves, adopts, and authorizes the president to sign resolution number 03-21-1123, a resolution of the Board of Directors of West Basin Municipal Water District, amending resolution number 1-16-1024 as it relates to Part 3, Human Resources of the Administrative Code, Article 2, Benefits, Section 3-4.216, Tuition Reimbursement and Professional Reimbursements Policy. It's a long one, but that would be the recommendation.
Fine, if there's no objection, it's so ordered. Thank you very much. We'll go on to the next item on the agenda, which is 6A.
Okay, thank you, Michelle. Excellent report. That moves us to our information calendar for today. And we have 3 items on the information calendar. The first one, as you know, the admin code, there's been some changes and amendments to that code and some updates, and our General Counsel, Steve O'Neill, is here to present some of the good governance principles and cover some of those updates at the same time. General Counsel O'Neill.
Sure, I think Julie's, thanks, Julie. If you could jump to the next slide. Yeah, I've been asked to review some of the changes that we've made to the admin code because as you can see, of course, in looking at today's agenda, the admin code is a living document and it's amended pretty regularly as needed. And I was just looking back at 2020. There was a couple of significant things that raised some issues that I wanted to approach, and also they kind of resonate with some of the things that Doug Brown talked about earlier. And so back in July, we had a couple of amendments that the first one under Resolution 1115 addressed the procurement policy, which is at Part 5 of our admin code. And that was a result of, like a lot of policies in our admin code, we are required to review them on a regular basis. I think Doug mentioned that on our disclosure policy this morning. Also with our code of conduct we review, and certain other policies in the district are subject to regular review for obvious reasons. and the procurement policy is one of those. We made some definitional changes that I won't get into. Also just wanted to note that we did authorize these cooperative purchasing agreements, which the district has availed itself, taken advantage of in the past, which usually we have some lead public agency that is soliciting bids and allows us to achieve some economies of scale on materials, oftentimes when there are large acquisitions that we can participate in. And also on emergency repairs. I know the board has wrestled with this issue in the past, and Director Alvarez, I imagine this is new for you, but in the past we had some issues where there were issues at the treatment plant or another one of our facilities where there were emergency repairs that had to be enacted, and the staff had to get people out there right away, and sometimes incur significant costs to fix something. And so we, in this resolution, we revisited that issue, and we required that there be a subsequent board ratification shortly after that expenditure. So the board is kind of in the loop on what has happened. We have a similar issue, Director Alvarez, with when it's not quite an emergency situation, but it is a critical repair or a critical acquisition. The staff has encountered some instances, I think mostly at the treatment plant, where there was a need for certain chemicals or a need for not an emergency repair, but something that was essential to keep the plant running. Emergency in the public contracting realm has a pretty specific definition. It implies an imminent threat to life or property. And sometimes there are issues that arise at the treatment plant that don't raise to that level of concern, but are still essential to maintaining good operations at the plant. And you'll see in the code that there is a similar situation with regards to critical repair, where the staff is authorized to make those expenditures. Then they have to bring them back at the next opportunity for the board to see them and ratify them. On Reso 1116, I just added that. That was an addition of the California African American Water Education Foundation to your pre-approved meetings. And again, this is for Director Alvarez, for attendance at meetings. The way the board has structured this, it's in the admin code and the code of conduct, which is found at 2-1.306. And I just included this because it is in addition to a list of agencies and meeting and different types of meetings for which directors have pre-approval to attend. You'll see when you look at section 2-1.306, the code of conduct, we created an exhibit attached to that lists all the meetings that directors are free to attend without prior board authorization. There's some obvious ones on there, of course, board meetings, metropolitan meetings, things like that. But then there are a fair amount of organizations that the district is associated with, which the board has determined would be appropriate for directors to attend, because the director's attendance would be material to promoting the interests of the district. So I just threw that in there because that was the one edit we made to Exhibit 1, and that has been revisited on a regular basis. Sometimes we drop some meetings, sometimes we add some entities or meetings, but that's the latest add to that. But I wanted to use that as an example for Exhibit A on the code of conduct. And Julie, if you could switch to the next one. And we recently amended the investment policy, the debt management policy, and your small and community banking programs, which you may recall coming through the agendas. But we also amended the disclosure procedures. And I wanted to bring this to the attention because Doug Brown touched on this, but we do have a planned financing coming up in 2021. It would be refunding of the revenue bonds, Margaret, I believe. And I just wanted to revisit that issue that Doug raised about when a statement that's made by a staff member or a director could reasonably be expected to reach investors. As Doug explained, it's kind of a broader, has a bit of a broader reach now. And I just want to remind, the staff and the directors just to be cautious in making public statements about the district's financial condition or other condition in light of the fact that we have a proposed refunding on the way. And the other issue that this touches on, and this is included in the admin code at 4-1.907 in this context, is that it's important that a director identify, or a staff member perhaps, identify when they're opining on a matter, that it's clear that the statement, that when it's made, if it's a personal opinion, it's very helpful to state that this is really a personal opinion. If it concerns the district in any way, because you have to remember the district by statute can only act as an entity or as the district by either a motion, a resolution, or an ordinance. So of course, each of those requires 3 votes to constitute an action of the district. And so if you have a personal opinion about something the district's involved in, it's important that that be clarified, that is your personal opinion and not an opinion of the district itself. And you'll see that's in the other parts of the code as well, that manifests in certain ways, that it's really important that when you're out there speaking about district matters, that you be clear that the district only acts as a district, as an entity. An individual director cannot act on behalf of the district, and if you're going to express an opinion, it should be clear that it is a personal opinion. So that's just a really brief review of some of the more important admin code changes that have we kind of incurred recently. And you'll see that the ones that we just did as well, looking at today's meeting on capitalization and on tuition, they're representative of how fungible or what a living document the admin code is, because things change, regulations change, statutory requirements change, and we're constantly trying to stay abreast of those and to keep up with all those changes to make sure our code accurately reflects what our obligations are, and also reflects the policy that's set by the board. And I've also been asked to take a look at, if you go next slide, Julie, just kind of a structural, a discussion of the structural concept of the district. And I know we've had this discussion on some level in the past, but I want to take a few minutes to go into it a little more detail about the essentially the division of labor in an entity like West Basin. And I'm just going to run through some of the principles and show how they're expressed by some of the organizations that are involved in special districts and cities and things like that. So as you know, the board is the legislative body of the district, and the city council, with the cities, it's called a city council, but in our situation with the water district, it's a board of directors. And you are the elected officials who perform the duties, and it's not your profession, but it's considered to be generally a public service. And that you sit in a unique position in that the board hires and supervises the general manager, the district council, and in some instances as a formal clerk of the board. And those are at that level of the organizational chart, essentially. Those are the people who report to the board, but the board sits, in some ways, sits above that and really sets policy through adopting legislation, controlling the budget, and the staff, through the general manager as kind of the top of that triangle, is charged with implementing that policy to run the everyday operations of the district and to hire and supervise all the district employees. Next slide, Julie. So this is kind of a little bit more detail on the duties and responsibilities of the board versus staff, but as board members, you're charged with, big picture vision, setting policy, deciding what's best for the district and its residents. And you do that through a variety of levers. You adopt a budget, you adopt policy as we're doing with our admin code, and to essentially legislate how the district runs. The big one, of course, you set rates, you approve capital projects, and essentially establish the policies to move the district forward. And on the other side of that, divide is the GM and his executive staff, that they're responsible for overseeing the daily operations and really implementing these policies. And all employees are answerable to the general manager, who then is answerable to the board. You'll see in the admin code when it talks about, I think it's in part 1 of the admin code, when it talks about the role of the directors and the way that directors are to interact with the district, and it's generally through the general manager's office and his executive staff. We haven't seen that in several years, but in the past there has been issues with certain directors who were no longer on the board, who were contacting employees directly, like lower level employees directly, and then it resulted in some confusion and some turmoil. So, we're set up to have that general manager's office and the senior staff, to some extent, be the points of contact. Next slide, Julie. And this whole concept of the kind of the division of labor manifests itself in our governing statute, and then the code, which we impose on ourselves. And importantly is this section 71326 that describes the role of the general manager. And you'll see that there is a condition at the beginning of this statute, quote, subject to the approval of the board, close quote. So that is an expression of the concept that the board is setting policy and setting the vision for the district, and through the different levers that we've described, through the budget, through the policies, through the admin code, and that the general manager, having gotten that charge from the board, has the statutory authority to essentially do the maintenance and operation of the district and its systems. And of course that includes the employees as well. And stepping down to the next level from the state statutes into our administrative code, you see yet another expression, and perhaps more specific expression of that the board shall provide guidance and instruction to the general manager. And again, you'll see the second sentence, individual directors shall not instruct the general manager. And that's, of course, an expression of the statutory requirement that the district can only act by majority vote. And so, and frankly, that exists in some extent to me as district council as well. The admin code says I work at the instruction of the board, which of course, again, is three affirmative votes, or the general manager. Next slide. I'm sorry, Julie, next slide. Oh, thank you. And this is a little redundant. I've got a Brown Act section in there that about majority vote. It's again talking about how the board operates, that in the public setting, of course, we have to have a legally noticed board meeting. Can't be no direction to be given to the staff by any one director. And see, this implicates the Brown Act. If the board's not, if there is individual interaction with one director and a staff member, arguably that is the board taking action outside of a notice meeting. The structure that is intended here, again, is the district's up here, your staff is here, excuse me, the board is up top setting policy, the staff is implementing, and through your board meetings, that is how the public is advised of what is happening and how that policy is being implemented, or perhaps how that policy is being set. But that's kind of how the Brown Act has an overlay on all these structural elements to make sure that the board is acting transparently and consistent with the meeting requirements. On 2-1.303, we see that same concept expressed again, that the board can only act through the board members acting as a unit at a scheduled meeting. Next slide, Julie. I think it might be the last one.
No.
Oh, yeah, these are just a couple of examples. Aqua doesn't have anything like this, but there are other agencies that, or I should say, essentially trade groups that express this same issue. You see it in the League of California Cities. They host an academy, kind of like CSDA does for newly elected board members of special districts. But the League of California Cities has a new council members academy that, we have this same policy expressed in here. Next slide. There's also the Institute for Local Government in California that is a place that's sometimes a good touchstone to look at these kind of governance policies. And you'll see they have a discussion on division of roles between elected officials and staff. And you'll see that it's essentially the same policy expressed, that the governing body appoints a general manager who is responsible for implementing the policy directives. Next slide, Julie. And some of the discussion in these that you see from these institutes like Institute for Local Government or the League is that it's important that these lines be respected, because number one, you want to be able to hold your general manager accountable for his performance. And if you have a strict adherence to this division of labor, it makes that a lot easier. On the other hand, you don't want to undermine your general manager's ability to perform by getting perhaps conflicting direction or inconsistent direction. By keeping this structure intact, you're really able to keep that direction clear and to hold your manager responsible for his performance. And also you avoid any kind of allegations of there being a district action outside of a Brown Act, and a Brown Act notice meeting rather. And is that the last slide, Julie, I believe? That's it. So of course, willing to entertain any questions. I appreciate your indulgence and your attention on this, and love to have a discussion or answer any questions about it.
Any questions?
Chair Deere, I got a question.
Go ahead.
Going back to the very beginning, Steve, that you were talking about on the emergency expenditure. Currently, what's the general manager's expenditure authority without going to the board for approval? Not for an emergency basis, just on a regular basis.
Oh, just for regular, for the procurement code, boy, let me look it up. I think is it 100,000, Patrick?
No, 50,000.
50,000.
Okay. So, can you explain in a little bit more about how the policy is going to follow up? Because I understand that $50,000 is not going to go very far in the case of an emergency.
Right.
And it is more than appropriate for the general manager to go out and incur expenses if there's a true emergency out there. So there's no issue with that. But you refer to subsequent board ratification. Can you speak a little bit to what that entails? And I'm specifically interested in knowing the time frame.
Sure. There is a, I'm just trying to find it in the code. So what's happened in the past, Director Alvarez, is that we've had probably more issues of this need for critical goods and services than we have had for emergency services. And the staff has, this is probably now 7 or 8 years old when this arose, where the staff has identified that something's come up where they need to either purchase some material or make some repairs to ensure that and generally it's the treatment plant, that to maintain the level of performance of the plant, they need to make some expenditures that exceed the GM's authority, but they don't have the time to wait for a committee and then a board meeting to get it done. And so we came up with this concept of procurement of critical goods and services, and it allows for the staff to use an informal but competitive solicitation process, and to the extent they can, it depends upon the nature of the criticality, I guess, but it has a limit of $250,000. They cannot exceed that, and then any expenditures for these types of repairs has to be brought back to the board of directors at the next regularly scheduled board meeting for ratification, because you'd be ratifying an exceedance of the general manager's authority. So that's one purpose, and the other purpose, of course, would be to let the board know that this had to be done.
Okay, so critical needs and services is you're differentiating, and I missed this completely at the beginning. I apologize.
No
From
worries.
emergency services. So in an emergency is pretty much do whatever you have to do and notify the board.
Yes, that's right. Well, I think
reasonable.
Yeah, it's best to look at the nature of the problem, I guess. That's the way we approached it. And, we've identified emergency purchases, that those are purchases that are needed to prevent imminent danger, to mitigate the loss of impairment of life, health, property, or essential public services. And staff in the past has identified situations where it's not that grave, that no one's going to lose their life, or no one's property is going to be destroyed, but the plant may not be able to run until there may be something that needs to be done to maintain the plant can run efficiently and provide the service you need to provide, and something has to be done before the next board meeting. So it's a lesser level of criticality, I guess, is what I'm trying to describe. And that's how we came up with this critical services and acquisitions concept. I hope does that explain it?
It does, but you also mentioned that in acquiring those services, that they're supposed to go out and get some kind of competitive bids.
Yeah, to the extent they can. For example, if I'm probably a bad example, but if they've run out of chlorine and they need chlorine for to keep the plant running, maybe they have time to make a couple of phone calls to try and get quotes, because of course they're incentivized to be efficient, and so we have an informal procurement process that they can follow for certain acquisitions that are below a dollar threshold. But in this situation, the code allows them to do the informal solicitation process, even though the amount may exceed it. But given the gravity of the situation, there's a kind of an understanding that they need to do it, and then to address the critical nature of the problem, and then bring it back to the board for ratification.
Okay, so a couple of comments. It really seems like the general manager has statutory authority to enter into contracts for up to $50,000, which is reasonable. And then
I'll say, I'm sorry,
the
go ahead.
statutory may be the wrong word to use, that he's been delegated up to $50,000.
Exactly.
So not by statute, but by some kind of resolution that the board or policy or administrative code.
Correct.
And then the general manager can spend up to $250,000 on critical needs and services. But he or she must bring that back to the board at the next regular board meeting.
Correct. And if I could just, as we've been talking, I scrolled through the code to find the definitions. And if this, you might find this helpful, Director Alvarez. For critical acquisition, we identify that as the acquisition of supplies, goods, and equipment that is unplanned, unexpected, and which is essential to the continued operation of district facilities, but do not rise to the level of emergency. And critical repairs are similarly defined. Repairs performed on district facilities that are unplanned, unexpected, and which are essential to the continued operation of the district facilities that do not rise to the level of emergency. So it's, as I was trying to explain earlier, perhaps not as specifically as these definitions, but it's a less critical situation, but still important in that it's needed to maintain the continued operation of the facility, which is in the past has been the treatment plant.
Okay. I think that one of the things that might be worthwhile in the event of that kind of expenditure, I know just from experiences with other agencies that, and maybe this happens anyways, but we might want to formalize it, that whenever there was a need to have any extraordinary expenditures, it could not wait for specific formal agency board approval, that was incurred, but typically within the day or 24 hours of, the general manager would contact the head of the board, the president of the board, to say, we've incurred this expense, etc. And if it was truly extraordinary, a lot of the times there would be some kind of special board meeting, so everybody would be appraised of what happened. We might want to formalize that a little bit more, just for consideration.
Got it. Okay.
One thing, Madam, excuse me, Mr. Chair.
Go ahead.
Yeah, and one of the things that is very important for us as a board, we are to act as a unit, is that there has to be we have to have trust. And if we have an organization where we don't trust the organization, meaning that us, and we don't trust our general manager to do the right thing, then we've got a problem going forward, because it is the trust that makes it possible for organizations to act and to carry out their their responsibility to the public, or our ratepayers and taxpayers. So we have to really be careful and how we trust each other, because it also it was pointed out earlier today with our bond attorney, that folks are looking at that if they see that there's a level of we have a lack of trust in the agency, which we did have a while back before the past election, that people will look at us in a different way. And then we don't seem to be an organization that is trustworthy. If we look like we don't have trust in our upper management. So I just would caution how we talk about this, and especially in public, that we need to be careful here. That's it, Mr. Chair.
Thank you. Other comments from my colleagues?
Sure. First of all, I didn't know if Director Alvarez was done or not.
If he's
Yeah.
not, he'll have a chance to
I'm
talk.
done.
Okay.
I'm done.
Okay. Cool. Cool. Okay. No, thank you. I did actually have a few comments and questions. I think the first one is having this presentation, the latter part of it, that really lays out the rules of the road, I guess, if you will, for the board and the staff, which, you know, hasn't really been presented in this way to us that I can recall since I've been here, except for probably one-on-one or at a retreat. But I was wanting to ask, you know, Patrick, is there a reason why this item was brought before us today in particular?
Thank you, Director Houston, for that question. Yeah, this was brought to my attention by President Williams, who had wanted any changes to the admin code or anything that would be beneficial to anybody just coming on the board, and a general refresher. And I asked this general counsel to prepare this presentation, bring it to the board's attention.
Okay. Well, have we had any incidents where directors are telling staff what to do or asking staff to do certain duties?
Not that I'm aware of. That's a question for each individual board member. I would hope not.
Well, I don't think that how would each of the individual board members know? We don't talk to each other because of Brown Act and different things, unless it's brought to our attention. So I was curious as to, you know, has there been any board members who've been intervening or, you know, asking staff to do certain things that the board's not aware of that prompted this?
No, again, Director Houston, the board president prompted to have this refresher training. That was the reason we're having it, which I think is good for everybody.
I do have a couple of other questions. So, because I want to make sure that, you know, all of us were doing the work the way we're supposed to do it, because we have had issues in the past. And Steve, you mentioned it as well. I think on these slides around page 6 and 7, you know, it talks about no individual director shall instruct the general manager in the execution of his powers and duties. You mentioned something about no director can be given, or excuse me, no direction can be given by any one director. And so I just want to make sure that I understand how that works, because we do on occasion send emails to Patrick and copy the board secretary, in most cases Julie, with requests. But I want to make sure I'm really clear on what type of request we can do or not, because I don't want to be out of compliance. And so the verbiage it's here, which I know it's in our code, but you know, you could read that different ways. So please.
Yeah, I see your point. I'm sorry. I see your point, Director Houston. I think a good way to think about it is kind of administrative versus policy. And for example, our code allows a director to request an item be put on the agenda. So as a director, you're free to contact Patrick's office and say, I want you know, XYZ put on the agenda for the board meeting. That, of course, that action that you're requesting is nearly not an action of the board, right? That's just acting, that's putting something before the board. It's a little different. For example, another one, could you sign me up for this conference, or could you make travel arrangements? Again, those are more administrative, kind of ministerial acts. They're not acts of the board. But if if you say, if you said, hey, Patrick, I want you to increase the water rates, of course, that would be a bigger issue. And so you have to, and I can tell you, I haven't seen it recently, but some prior directors, we did have issues with that. And I don't see it certainly with this board, and I haven't seen it in recent history, but in the past, that has been an issue. And I'm also conscious of the fact we now have ad hoc committees, right, that were recently formed that haven't been, really the district hasn't had a lot of experience in recent times with ad hoc committees. And, that is a kind of another animal, but it is the board working, kind of giving direction a little, at least two members of the board, giving some direction to staff. And that's kind of it's kind of an in-betweener here, in that they're, the board are policy makers, and that staff are the implementers. But the board has identified for certain subject areas, both staff and the board could profit or benefit from having that kind of structure to vet some issues and work a little more flexibly through the ad hoc structure. So I guess I'm sorry, I'm going on here a bit, but to get back to your original question, I think for the individual contacts you have with the general manager's office, to the extent that they're administrative and ministerial in nature, and you're not asking him to take a position that would be subject to the whole board, the whole board's consideration, you should be okay.
Okay, no, that helps a lot, because quite honestly, yes, you mentioned past directors, but even current directors, people get accused, if you will, of giving directives, and that was the word that was used, directives, to the general manager when they were just mere requests. So I'm just saying what has happened in the past. That's what, and you were on these kinds of emails, so you've seen what was happened in the past. These words were used. One thing I concur with President Williams, is that, we need to have trust. And I think that simple emails that are sent making requests, they're administrative, they're not deemed as directives, unless someone wants to use that word. Maybe we should look at the words we use, but requests, that's what they are. And so I wanted to make sure I understood the rules of the road, because this is, it's the first time it's been so put right in front of our faces, if you will, in a public setting like this. So I do have two other questions, one or comment or question, whatever. The point is this: I did make a request to the general manager about an upcoming agenda item for the workshop regarding our expenses, and I haven't gotten an email back from him. So Pat, I don't know if you received my email, but I assume you'll answer the request for the upcoming workshop on expenses.
Yeah, I passed your request / directive on to Margaret, and she's working on that. It will be on the, I think it's on the workshop next. Margaret, when is it, the 24th?
Correct. The information is being will be presented on the March 24th.
Okay, good. Thank you, Margaret. And I don't like the word directive. I don't know why that word keeps getting used. These are requests, not directives. But either way, the general manager, I would appreciate, would reply to my request just to let me know you received it and you're acting on it. My last question is this, and this is really a combo for Pat and Steve. I understand how we, the board, work through Pat, and that's what I do. Now, here's a question. What if our staff, for some reason, don't feel comfortable if they had to go to whether general manager or executive management for some reason? What other recourse would staff have to deal with any concerns they have within our organization?
Well, I'll defer to Michelle on that, but generally the structure is the staff should go within the staff hierarchy up to their supervisor or their I forget the title, if it's their department head, if they have issues about employment issues. But Michelle, I'll throw that one to you.
Sure. If staff have issues, I guess, within, the organization, they would normally come to human resources. And depending on who, I guess, or what level of management that, concern or issue is with, I would either then go directly to the general manager on that issue, or I would go to district council and then seek further advice as far as how to proceed from there. But initially, though, the individual would come to me as the human resources manager. Now, if the problem was me as the HR manager, then I would assume they would go then to the general manager or to district council on those concerns.
Okay, and there's obviously reasons why people may or may not want to go to certain folks within the organization, but what happens if they go to a director and express their concern? What would be the step the director would take to bring that to someone's attention at the agency?
I'd offer Director Houston that if that did happen, that you would refer that employee to human resources as the first stop.
Or maybe to your office, Steve?
Of course, yeah, I'd take the phone call, but I'd likely engage Michelle right at that time if I was the first contact that they made. But I believe the best course or the best practice would be to use your HR office.
Okay, but you could understand where some people would have concerns that, they may have issues that they're not comfortable with the normal channels. What other recourse do they have? Do they go to the law enforcement, or who do they go to?
I was just going to also add, Director
Okay.
Houston, that our administrative code also speaks to the fact that if an individual has a concern regarding any type of harassment, any type of Title VII violation, they always have the right to go to the Department of Fair Employment and Housing, or to the Equal Employment Opportunity Commission. The DFEH, which is short for Department of Fair Employment and Housing, is a state agency, and the EEOC, Equal Employment Opportunity Commission, is a federal agency. And so there's information in our administrative code on the fact that they have the right to go to any of those agencies or both to file a complaint or any concerns that they may have without having to go to the Human Resources Department, general manager, or to general counsel. So that's also a recourse that an employee would have.
Okay, good. Okay, let me ask one last question. What about, can they also come straight to the board in closed session?
I'm going to defer to Steve on that one.
Without availing themselves of the process in the administrative code, I'd recommend against that. I mean, we have the code with a structure for a reason, because in that situation, they would not be going to HR or to the general manager. They'd be going right to the board. The best practice would be to go through HR, and it's kind of a hard question to answer in the abstract, but I just recommend the best practice would be to follow the code and contact the HR office as step one.
Okay, I guess my biggest concern would just be to make sure that we're able to protect the staff if executive management became aware that a board member had been contacted. You know what I mean? From any kind of retaliation. So maybe that's something, and I know it's a bigger discussion perhaps. Maybe that's something, you guys can just send me a note about, or how that works. But I think it should be really good for us to understand the rules of the road, but also I can understand where sometimes staff may not feel comfortable with the normal channels. So,
I will add, Director Houston, that the administrative code also speaks to the complaint process. If an individual feels that they want a complaint, and it speaks very specifically as well to retaliation, and that there should be no retaliation for any individual bringing forth a complaint or taking part as, you know, in an investigation regarding a complaint or other issues. So the admin code is very clear in that there should be no retaliation by in any forum, you know, if someone were to bring forth any type of complaint.
Sure. Good,
So
good.
there
No,
are protections.
thank you very much, Michelle. At the end of the day, too, we all hear what's going on at Metropolitan. You know, maybe it's all accusations, but retaliation does happen, even if it's not on the, you know, if it's not against the code. So anyways, I just wanted to understand and make sure that I'm following the right rules too when it comes to making requests of general manager, you know, when it comes to run of the day items. So, so thank you. And thank you, Steve.
I think it's also important that we, this is Don talking, we are cautious of how we treat our employees and get away from that micromanaging problem that sometimes city councils or boards have. We have to know our roles as board members, and I think we've learned a lot today from our refreshment courses here. Let's go on. Anyone? Comments? If not,
Wait a minute.
all right, go ahead, Director Williams.
Okay. Thank you very much, Mr. Chair. Since I brought about the 3 ad hoc committees where that we haven't had in a while, we haven't had an ad hoc committee. I just want to know, in an ad hoc committee situation, how does the West Basin Code section 21.303 works? I mean, is it?
I don't have that code in front of me. Was it on one of the slides?
No.
Yes, it's on page 72
Hang on.
of the of your slides.
Got it. Okay. Can you, is my microphone on? Hang on. Okay. Let me go back to it. Sorry.
We have a situation where
I'm sorry. I had to pull up the slide. I'm sorry. So 2-1.303. Oh, this is the one that talks about the board acts as a unit at scheduled meetings, that it's reinforcing the concept that the board as an entity can only act by resolution, motion, or ordinance, which of course means that as to municipal water districts, that's 3 affirmative votes. It's not at a majority of the quorum, it's a majority of the board. You have a 5-member board, so it's always 3 affirmative votes. If there are only 3 board members at a meeting, it cannot act on a 2-to-1 vote. It needs 3 affirmative votes. And that when you look at 303, when it says the individual members have no independent authority, that's to reinforce that same concept. 1 director cannot bind the board, essentially. And you know, the last sentence is really self-evident that, you know, the board members have a duty to obey and all the lawful orders of the agency. So it's really when you think about this, Director Williams, in the ad hoc context, that there'll be board members, and it's not going to be a majority of the board. I think that's what you're getting at. It'll be 2 board members. Yeah, and so they are really to kind of guide policy and have and to work cooperatively with staff in coming up with policy recommendations for the full board to consider. And it is again, it's not intended to be the standard operating procedure moving forward. Ad hoc committees are designed to be of limited duration and to handle discrete issues. And I think that's what you've identified when you created those committees for the issues that we talked about that they were created for. So how 303 kind of integrates with the ad hoc structure, I think just the board members have to remember that even though they're on this ad hoc committee, that they are really hoping to kind of clarify and craft policy with staff assistance, but with the expectation that once that policy is considered and adopted by the entire board, that the staff will be implementing that policy and not an individual board member, if that makes sense.
Anyone, any questions?
May I have my meeting back? Director
Yeah,
Webb?
I think Director Alvarez has a question.
No, I don't have a question. I'm sorry, I did leave my mic on.
Okay, then we've had this information and we can receive and file it. Let's go on to the next item on the agenda.
Thank
Item
you.
6B.
Yeah, thank you, Chairman Deere. Yeah, item 6B pertains to a credit for a service connection meter water West Basin 0-06B. And we have been, this has been a long-running issue over a meter that's owned, operated, and maintained by Metropolitan Water District, one of their turnouts that serves, I think, down the PV area through Cal Water. Anyway, we have got a final determination on the disposition of the accuracy of that meter from them just in January, and they issued us a credit because the meter was reading in error, and then we passed that credit back to our retailer, Cal Water. But we have Margaret here to cover this item. Margaret?
Yes, good afternoon, directors. So as Patrick mentioned, this is I'll say a good news story. Again, this allowed us to be part of the process to really help one of our customers to provide sort of a corrective action to an inadvertent billing error. So go back a little bit to it, is that in October 2017, Cal Water did contact Metropolitan directly to indicate that they had an issue with one of their meters, WB06B. And through a number of years of sort of testing and providing information from Cal Water to Metropolitan, and we were brought in sort of a part in the middle of all of it, we were finally given a determination on January 24th, 2021 on the letter. And that letter is shown to you on page 79 of your board packet. You can see there that they did agree that there was a billing error and that they would credit back 851.5 acre feet in the amount of $864,391.50. So going back to the board memo, I just wanted to share with you the table that you see there at the bottom of page 77. You can see that not only did there was the credit that was given back to us by Metropolitan Water District that we were able to give back to our customer, but because we had billed those and what we believed to be right sales at that time, we had also included our own individual charges, which is our reliability service charge, the RSC, as well as our RTS credit, which is our readiness to serve charge. And so you can see that the combined of those two numbers, the 288,644.90, was also returned to Cal Water to them for a total amount of a credit of $1.1 million. Now, we wanted to understand the accounting treatment of this particular charge because, again, this is something that occurred, as you can see, over 3 different fiscal years. And we do understand that this cost would be considered a non-operating expense, would not be accounted against us, if you will, in our debt service coverage. And so we are understanding of how we need to account for this particular thing. But again, a good news story to share about one of our customers, to Cal Water, able to work with them to finally get resolution with Metropolitan on this item and a credit of $1.1 million. And with that, I'll turn it back to you, Director Deere, for any additional questions.
Thank you. Why did it take so long?
It's my understanding that there was some readings that needed to be done, some calibrations and analysis that needed to be taken care of, and this hydraulic analysis, I should clarify. And so there was some work that was done in 2019. And again, Metropolitan put in a temporary meter. So a lot of this needed to go back and forth, and Metropolitan needed to understand why in the first place that did they have these reads against these things put in that meter, then read it again and see where it happens. As you can tell that we did have it throughout the period of time, mostly through 2018, but the work was really done in 2019 and follow through happened in 2020. And it wasn't until sort of, I think it sort of resolved itself, I think, end of 2020, but the letter officially was received by us in January 2021.
Thank you. Are there any other questions from my colleagues? Well, very good, and thank you for that information. Item C, monthly financial report.
Thank you, Chairman Deere. We have Mary Ann Rexroad who's going to cover the various components of our monthly financial report.
Thank you, Patrick. Good afternoon, Chairman Deere and members of the board. I think I'm the only thing holding you from lunch, so I will be thorough but as quick as possible. If I could ask you to all please turn to page 82 of your packet. That's the beginning of the demand list for the month of February. Just as a reminder, these demands include all payments made by West Basin. It covers both of our operating and our capital payments and those projects related to that. So as I mentioned, 82 starts the beginning of the demand list for the month of February. If you scroll down to page 88, I believe, you will see the total for the month, which was 16.3 million. That is slightly lower, or actually more than slightly, it's about 3.5 million lower than the prior month. But you may recall that in January, we did pay our semi-annual bond payment in January. So that's the reason for the lower amount this month. Just one other item I'd like to point out that I'll open it for any questions. We did make a payment to regarding our interest on the commercial paper program that you heard Margaret mention earlier, that we'll be looking to refinance later in May. So with that, I will stop and see if there's any questions before we move on to the next report.
I guess there are no questions.
Okay, thank you. So moving on to page 89, at the very top left-hand corner, you can see our total market value as of 2/28/21 is about $91 million. That is an increase over the prior month of about 5.3 million. This increase is primarily due to a $5 million draw that was made on our CP line and was invested in our securities that you see here on this report. We also did receive some standby money during the month of about 700,000. Again, all those dollars were invested during the month, so therefore increased our total market value. If you move down to page 90, these are our two bar graphs that we share with you every month. The top bar graph shows the credit quality of our portfolio, and that lower half of the page will show you our maturity distribution, again, as of 2/28/21. The next page, on page 91, you will see this is the transactions of all the buys and sales during the month. Again, you can see on the top half, the buys exceeded the sales primarily because of the $5 million we received from the commercial paper program. The next several pages from 91 to 94 are all the detailed lists of the securities that we have in our portfolio. Again, I will stop there before moving on to the next report to see if there's any questions.
Guess not.
Okay, if I could ask you all to move to page 95 of your packet. I'd like to share a few items on our sales. This is all of our water sales through the month of February. Starting at the very top of page 95, you'll see these are imported retail sales. And just want to point out a couple of things on this top chart. You see for the month of February, we did have a slight dip from the prior year as well as from budget. We did have about a 1,300 acre feet drop from prior year and about a 500 acre feet drop from budget. We did look at some of the reasons for that. One reason we think could be attributing to this is that there was a shorter month last year. If you remember, there's 29 days, we had 28 days, but primarily looking at it from each of our retailers, we do see some drop in their purchases. We are looking at their usage of groundwater, and we are waiting some more information from WRD that would help us to make this analysis. But we will continue to monitor this situation. But the good news is, if you look through the end of the fiscal year, we are still trending above our budget. You can see that for the fiscal year 2021 through February, we had 69,930 acre feet of retail imported sales compared to a budget of 68,667. Again, we are still slightly trending ahead of our budget. Moving down to the imported barrier sales, as you recall, this is made up of our two barriers that we inject our potable water into, both the Dominguez Gap and the West Coast Barrier. Again, we are trending really close to budget. For the month, we had 387 acre feet that was purchased versus a budget of 392. We are trending a little bit lower than last year, but again, these are sales that we don't control. This is determined by the County of LA and how much their injections are into the two barriers. Moving on to the year to date, again, you'll see we're trending very close to budget. The primary or the majority of the 3,100 acre feet that we had in sales were injections into the Dominguez Gap. And then moving on to page 96. At the very top is the recycled water sales again in the month of February. Again, for the recycled water sales, we are trending right on to not only last year for the month, but also with budget. As you can see in February, we budgeted 2466. We had actual sales of 2474. When you look at the year to date, you'll see we are trending fairly close to last fiscal year, but slightly under the budget. I'm sure you recall our conversations that we had during the last quarterly budget versus actual. We did have some limitations on injections into the West Coast Barrier based on the county's requirements and their instructions. And then last but not least is our brewer desalter at the very bottom of page 96. We had no sales to report for the month of February. Again, I'll just pause there to see if there's any specific questions I could answer on our water sales.
Apparently not.
Okay, all right. Well, then moving down to the next page, page 97. This is the Director's Conference and Travel expense. This is through the month of February. You can see the total spent to date was about $4,000 out of an annual budget of about $75,000. So we have a very healthy remaining budget of about $71,000. And then moving down to the next page, this is the executive management and staff travel expenses. Again, trending very much below budget. We have a total of almost $12,000 out of a budget of $150,000. So again, our remaining budget of about $138,000. And that concludes my report, but I'd be, again, happy to answer any questions.
Apparently none. Thank you. Good, very good report.
Thank you.
There are no closed session.
That's correct.
And now we're under director's comments. Director Williams, any comments?
No, thank you.
Okay. Who was the next one in line? Director Houston, any comments?
Sure, just really quickly. One is I want to say I did get that memo that was requested last month at this meeting. It came to us about an hour or so before this meeting. So again, it was about a month, and I did get this memo regarding the credit card issue we did talked about last time. So I haven't had a chance to read it, but I will be reading that. And secondly, I do think as things are starting to open up, and even as I'm sitting here, I see that even local colleges are starting to plan to open back up in the fall. Maybe the committee could look at having this as an item next month, a report as to where we're at and how we would start reopening our office building, and how staff starts working in person again, and how the board may eventually start meeting in person. just to keep us appraised, because things are starting to open back up. So that would just be a request. And that's it. Thank you, Mr. Chair.
You're welcome. Desi, comments?
Actually, Director Houston just tickled my interest in this. Has the district made arrangements for having all of the district staff vaccinated? This, I guess, for the general manager, have you guys reached out and looked at having all of the district staff vaccinated? Maybe that's already ongoing.
Right, I think, well, Michelle is not with us right now, but I see Steve still on the line. We know we haven't, although several of them appear to have gotten vaccinated, but we are looking at issuing a letter that would allow them to be treated as essential public service employees. Oh, there you are, Michelle, sorry. Do you want to address this, where we're at on that communication to staff? Steve involved?
Sure. So we are looking at giving a letter to staff that could potentially put them in a position where they can take that to get to certain, forums where they could potentially get vaccinated. Metropolitan has put out a similar letter. That letter for the district staff cannot mirror necessarily Metropolitan's letter because of the fact that while we are to some degree essential infrastructure workers, it's not to the degree necessarily that Metropolitan's employees are. And so the letter would have to be curtailed a bit. And Steve is working on that letter, or has worked on that letter for the district. So again, what's happening at Metropolitan and other agencies is that some are taking this letter with them to certain vaccination sites to see if they could get some type of priority for vaccination. We have not mandated vaccination here at the district. There's a lot, so far I don't know of any public agencies that are doing so. I have been attending numerous conferences and webinars through various HR legal forums and otherwise that speak to that issue. And there's a lot of liabilities and issues to consider if you, as an agency, start to mandate vaccines. However, in order to give individuals a certain push, we could potentially give them a letter that places them in a position where if they choose to get vaccinated, they can do so. Because again, it is also an individual decision as to whether or not employees would want to get vaccinated. And Steve, I'll turn it over to you if you have anything to add to that.
Yeah, I think you covered most of it, Michelle, but Director Alvarez, we got a letter. I think the general manager at Metropolitan said to most of the member agencies that was a letter that they had prepared for their staff, essentially to bring to vaccination sites, which is, kind of not a doctor's note, but a statement that they are eligible for vaccine because they are essential service providers. And we've taken that and made some edits to it to talk about what role the district does in providing, water to who the district is and what the district does in providing water to its service area to hopefully, convince whoever's on the other side of that conversation that the holder of the letter is entitled to a vaccination at this point. The letter also states it confirms that the employee is an employee of West Basin, and if they have any questions, they can call the district to confirm the employee status. So that's where we are with that. We should have a letter shortly that would be available.
That's good. I think vaccination is a great opportunity, and that the district should be trying to do as much as it can to encourage the employees to be vaccinated and make that very easy for them if they choose to do so. There are multiple agencies that have arranged to have their employees vaccinated. And a lot of people have been vaccinated that way. And in addition, if you read the latest series of people that qualify, I think that water professionals that work for agencies, I shouldn't say water professionals, but in agencies that provide water and sewer services come under that. So I would encourage that the general manager might want to reach out maybe to the South Bay Health District. They're doing vaccination. They probably would be willing to make arrangements for those employees that want to get vaccinated to get vaccinated and make it easier for them. I think there is at least some people that I know, and I've been vaccinated, and I'm very happy to have done so. So there's a lot of interest in people to be able to get vaccinated, and I think we ought to do as much as we can to encourage people to do so.
Yeah, we'll follow up on that, Director Alvarez, and just a reminder, we're not mandating it for folks to do it, and some have already expressed that they may not want to do it. But yeah, we're, as Michelle and Steve alluded to, we're on the precipice of having a letter that will help facilitate that as much as possible, as long as they're willing to do and interested in doing it themselves of their own volition.
Well, it's too bad the board, I think 4 board members have set the example. One board member is a little too young probably to get the priority, but the rest of us have been vaccinated. And City of Gardena is taking care of senior citizens at Memorial Hospital, and it's pretty fast there.
Mr. Chair,
Go ahead, Director Williams.
I'm also a commissioner for the County Public Works.
Mm-hmm.
And early on, Public Works employees of county could go to the vaccination site with your ID, show your ID, and you could move through the line. So I would hope that we would put it in such a way that employees don't have to carry a letter with them, but they can just show their ID at the particular site and move through the line. Thank you.
Okay. Anything else?
Chair Deere, along those lines that Director Williams said, not only the County Public Works, but other agencies out there basically made arrangements where all the employees had to do was take their ID card, and they called, they set up an appointment, they said, I'm with so-and-so agency, and then all they had to do was show up at their appointed time and present their ID card. I think the South Bay Health District, which now is giving vaccinations, would probably work with the district so that those employees that want to get vaccinated can do so by calling, scheduling the appointment, and all they have to do is show up with their ID card. And they don't have to then kind of go through a more difficult process. Because you can always go through and try to find a vaccination site that has openings, schedule an appointment, show up with your letter, etc. I would like to see if we can make it easier for those employees that are interested in getting vaccinated to do so.
Very good. All right, Mr. General Manager, you're going to follow up on that?
Yes, Chairman Deere, certainly we were already looking into all of this, and the input's been very valuable. And by the way, I think quite a few of our employees have been vaccinated from different ways. There's different ways to get vaccinated, but anything we can do to help without mandating it, we certainly will.
Very good. Are there any other comments from directors? As per the agenda, I want to congratulate staff today. They all gave excellent presentations, very, very informative. And if there's no further business, we are adjourned. Thank you.